Next up on This Week in Law, Larry Downs and Terry Karabonic join us. We're going to talk about Google Glass and cars and liability, liability and law machines, lots of pending legislation, and lots more next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown, episode 234, recorded November 1st, 2013. Tech Policy meets Traffic Court. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. I'm really, really excited that you're here with us this week because we've got a number of very interesting topics and some great panelists. Lots of things regarding the collision of technology with the way we do things in the world and the legal ramifications of that. So we're going to get right into it. We had last week from New Media Rights, its founder, Art Neal. Joining us this week from New Media Rights is Terry Karabonic. Hello, Terry.
Hello, Denise, and thank you so much for having me on.
We were joking around before the show, making sure that I would get the pronunciation of Terry's name right, and I almost called you Karabonic, even though we checked it. But I'm just going to have to remember that it's Karabionic. Karabonic. So glad to have you. We talked a lot last week about the kids who made the library video, and I understand you were one of the main point people on that.
Yeah, I was the one basically that got the phone call when it came in, and it was it was a really interesting case to get to work on just because it was such a good video and such a good example of a parody, and that it was really nice to be able to get that video back up for them. Yes,
very cool. If anyone's wondering what we're talking about, go back in time to episode 233. We played a bunch of the video and just went kind of deep on the parody and fair use ramifications of this video that was removed from YouTube, and then it had its audio track removed. And thanks to Terry and her friends at New Media Rights, it is back in business. And that's the kind of work that they do, is representing users primarily and creators when they run up against issues regarding rights and other things concerning online works. So great to have you with us, Terry.
Happy to be here.
Also joining us, one of our favorite return guests to the show, Larry Downs. Hello, Larry.
Denise, you pronounced my name perfectly. That's great.
That one is hard to botch. I'll see if I can start calling you Downies or something, just so you don't feel, left out.
It's great to be back. I really missed the show during the forced exile while I was writing the new book. So I'm glad that's behind me for many reasons.
So the writing is done. Is the publishing also done? Is the book available?
This is the uncorrected galleys of the book. So it should be starting to show up in major channels in the middle of December. The official publication date is January 7th, which happens to be the first day of the Consumer Electronics Show. So we'll be doing a launch event there in Las Vegas.
Oh, perfect timing.
Yeah.
That's great. And we have some Big Bang disruption, at least one Big Bang disruption related stories to talk about today. So I'm very glad that we have you here. And again, we were joking before the show, Larry, that you're such a prolific writer and you go so deep on so many juicy issues that, it's Evan and I kind of hold our heads and go, oh gosh, Larry's coming on the show. We have lots to read. So for anyone who is interested in keeping up on Larry's reading, he writes regularly at Forbes and elsewhere. And the things of his that we're going to cover on the show today, along with everything else we discuss, are in our delicious links for this episode at delicious.com/thisweekinlaw/234. But we're not going to start with one of Larry's pieces just yet. We're going to start with technology and cars, and specifically Google Glass and cars, because during this week, a woman named Cecilia, and again, who knows how she pronounces her last name, Abedi, I'm going to guess, received a ticket in our great state of California here for, and in fact, it happened just down the road in San Diego, for driving around with her glass on. She is one of the glass explorers. She's definitely a glass evangelist, it sounds like, and loves using her glass, finds it a helpful thing, including, no doubt, the fact that it will assist you when driving. I don't have one, but I understand that you can access GPS and maps and things on Google Glass the way that you could on a monitor in your car or on your phone. Here she had her glass on her head with the monitor visible, and that's what she was ticketed for. When she received her citation, she was written up for having the monitor visible. So at least one officer of the law in California feels like that's equivalent to, having a movie on the video screen in your car while you're driving, that this is not an okay thing and you're going to get a ticket. So people are urging Cecilia to fight the ticket and see, what exactly the status is for glass when used by drivers. Evan, I knew you would find this interesting.
Yeah, it is interesting because, here we go. We have old traffic laws, or at least laws that predate the introduction of this new technology being applied to that very new technology. So, it's really interesting to see the reactions that people have to this. If you look at Cecilia's, all the comments after she posted it onto her Google Plus page, all of the people, and, I think unanimously people were like saying, oh, this is ridiculous. I can't believe you got that ticket. You got to fight this. Let's put together a legal fund to help you. Why doesn't Google send a lawyer to show up on your behalf and all that stuff? And so, it's really interesting to see how homogenous the reaction to this is. But wait, let's stop and think about it here. Isn't it a good thing to be prohibiting somebody from wearing Google Glass while driving? Because it could be enormously distracting. I mean, how many times have we talked about the perils of texting while driving, as we've seen over the last few years states enact legislation to prohibit texting while driving to get at this problem of distracted driving. So, setting aside ultimately where it comes out on this, whether or not it, we could sit here and we could parse the language of the California statute and all that stuff. Setting that aside, should we be so quick to say that, oh, this is terrible that she was ticketed for this? Do we really want people driving around with that potential to be distracted? And people actually will become distracted by using Google Glass while driving. Would you want to be walking in, trying to cross the street with somebody who was reading tech dirt while, wearing a Google Glass, or worse yet, have your 5-year-old kid walking out in front of the street trying to cross the street with a distracted driver like that. So, setting aside where it ultimately will come out, I just am not so quick to say that, yeah, fight this and have it be vindicated that one can wear Google Glass while driving. I think as a society, we may want to, pause and think, well, maybe there is something to this ticket.
Yeah, you make a good point, Evan, in that I referenced the video displays that are available in so many cars today. And there's a California driver handbook suggestion that says, and this comes from Ars Technica's coverage, John Brodkin over there writing about this story. The California driver handbook says, do not drive a vehicle equipped with a video monitor if the monitor is visible to the driver and displays anything other than vehicle information, global mapping displays, external media player /MP3, or satellite radio information. So it's interesting that is the DMV's interpretation of the California law. Because if that's the case, then certainly glass would be a problem there because it does things other than just as described. But so does my Ford. The screen that comes standard in a lot of cars does other things. It won't play a movie for me, but it certainly does things other than on that laundry list of stuff. If I'm looking for a certain kind of restaurant, it'll give me that information while I'm driving. So, not only, is Google not compliant with this particular rule in the glass technology, but the car manufacturers themselves, I think, have got to be sort of all over the map, not to make a mapping pun.
That was good.
as to what their not heads up displays, but their in-dash displays can do. Larry, do you have any thoughts on this?
I sure do. I mean, mostly I agree with Evan, but part of the problem is that it's not just state law. There are local laws that are different about distracted driving or about displays and where they're allowed to be and where they're not. Probably the answer is because there's so much change going on that we really need kind of uniform federal distracted driving law that can take advantage of knowledge about how things are changing. I had the opportunity to try Google Glass a couple of months ago, just briefly, so I can't really say, but I can imagine I certainly wouldn't want to be wearing it while I was driving. I mean, I have enough trouble as it is. But what really amazed me, and Evan pointed this in the Google Plus page for the woman who got the ticket, was I don't know why I'm amazed, because it's the case all the time, but everybody's giving her legal advice. And, I don't go to the plumber's house and start telling him how to do the pipes. But somehow when it comes to legal things, anybody who thinks they've, read the ordinance or the law, or thinks they've read the ordinance law, feels like, that's all they need to know to start giving advice about how to interpret it or how to fight it or not to fight it. And the last thing I would imagine somebody would want to do is try to, fight a big tech policy issue in traffic court. Those are not really the judges who are best equipped. They want you out of there at all costs. This is, I would say every piece of advice on that Google Plus page was truly bad advice. And there should be a law against giving legal advice if you're not a lawyer. Oh, wait, there is a law against legal advice if you're not a lawyer. We should really enforce that much more heavily.
Oh, I love that. Well, I mean, if not in traffic court, then where, Larry? I mean, every case starts somewhere. This woman, I guess, could take this all the way, take it up to a higher court or the highest court, I suppose, to get the serious policy consideration that it deserves. But the thing that strikes me is, yes, you don't want distracted driving, of course. But what you do want is the most efficient and non-distracting way to display that information that drivers need. Yeah. So, in my own particular case, as I said, I have a Ford, which has my Ford Touch and its navigation system. And right now, its navigation system needs to be updated. And I'm trying to remind myself, I can't remember if Leo Laporte still drives a Ford or now he has a different car, but I remember seeing him tweeting recently that his GPS was showing him in the middle of Bodega Bay. And mine has been doing similar stuff. I've been halfway out to Catalina lately every time, the car tries to locate where I am. So it clearly needs an update of some kind that I haven't been able to apply yet and haven't been able to get it into the shop. So its mapping system is not working for me. What I tend to do, and I don't think this is strictly legal in California, is turn on the phone mapping system before I leave, before I'm driving, if I need to find my way to somewhere, and just leave it sitting on the seat next to me. And then it talks me through. It does the turn by turn and I don't have to touch it. So that's been sort of my stopgap. But if Glass is able to provide you with, non-distracting navigation information in the best possible way, then, I think that I want laws that recognize that. And I guess we're getting back to, Larry, what traffic court can't really parse and decide, but I'm hoping that someone somewhere can.
Yeah. Well, as I say, I think, a federal solution to traffic safety is, of course, both a state, local, and a federal issue. But for this kind of thing, you want uniform law, and there's nothing, there's nothing local about the problem. So, I think if Congress kind of looked at it and decided how best to do it, that would really be, and then we've got one solution and it can be litigated in one place if necessary. I think that's, going to make more sense than every tax abatement district or mosquito control ordinance having its own view about how technology should be implemented.
Yeah, good point. Terry, what do you think?
I mean, I do think that Google Glass could be really helpful and actually less distracting than a lot of GPS devices already on the market. But I think we're going to have a practical problem with implementation. Ultimately, it's going to be very hard for most police officers decide when they've pulled someone over because they're kind of swerving and appear to be distracted, whether the Google Glass was on, what that person was actually looking at. Since from what I've seen, you don't actually see in the Google Glass whatever that person is looking at. I could be wrong. I haven't had a chance to play around with the Google Glass a lot. But it's going to be very hard for a police officer to discern what the Google Glass is actually being used for. So I think we might really, from a practical perspective, I think the easiest way would be yes, Google Glass, no Google Glass. But at the same time, I really do think that Google Glass has some really excellent uses that would lead to less distracted drivers. So I'm not sure if we will be able to come up with sort of a practical legislative solution on this.
Terry, I really love an issue you're raising there, and one of the folks in IRC was saying, well, apparently this Cecilia didn't have the glass turned on, which, you know, then of course it would be a harmless. And so I love thinking about this and how we could see where this could go into the future. And recognizing what you're saying, Terry, that this is an implementation problem and an enforcement problem. You'd probably agree based on what you were saying there. Because think about where technology may be going in this regard, becoming more and more embedded into the body. You know, sometime we'll be able to actually be able to wear our well, we're already wearing devices with Google Glass, but like to actually have them become a part of the body. You know, embedded microchips and other ways of having hardware become part of our biological substrate to have this augmented reality. So how on earth would you, like, say, for example, there's technology that allows us to access the internet and see, I guess it's with our mind's eye, content coming from, without, through some kind of contact lens or what have you. How on earth are you going to enforce the public policy of avoiding distracted driving in a situation like that, where it's not as obvious as somebody wearing glass? I'm asking that as more as a rhetorical question, but that it's an interesting thing to think about where this could go in the future, and the enforcement could become much more difficult.
Well, I guess this all plays into, although I didn't put it in the rundown for this week, the announcement that the FAA is going to allow most electronic devices to be used throughout flights, so you don't have to have that window of time at takeoff and landing where the devices have to be off. You're still not allowed to use the voice function of your phone or the now I'm not sure how they're going to limit using data, but I think that what the rule is that you can't. You could use your phone as a reader, you could play games, you can use the devices in a non-transmitting mode. So what that does, I think, is just make life easier for the flight attendants, right? They don't have to go around and be the bad guy saying, you got to turn off your device, because the devices can be on, and it puts it on the passengers to follow the rules. And if they're not following the rules, then, I guess if you take it to its logical extreme, they're doing something arguably unsafe for themselves and the rest of the flight, and everyone on the ground under the flight, for that matter. So, are we in a similar kind of situation there, Evan, that either you're going to have to put some sort of restriction on the device that prevents it from being used in an unsafe situation, or you're just going to have to trust people?
I mean, we already trust people. Well, this is one of those answers I ought to sit and think through before really giving an answer. I mean, there are already situations where people do things to make them less good of drivers that aren't visible to the naked eye from outside of the car. The obvious example is drunk driving. It's very difficult, just to look and recognize immediately with the same amount of conspicuousness of somebody wearing a piece of hardware, whether that person is intoxicated, because that status exists inside the body. The blood alcohol content is not something that publicly displays itself, except through behavior that you have to look at for a few moments, at least here. So, it's probably there could be some amalgamation of those enforcement mechanisms of, the recognizing that there is a piece of hardware, an outward sign of it, and the internal state that does rely a certain amount on human honesty. And there could be technological solutions to this as well, actually seeing to it that cars don't operate, or that that the operation of those two things at the same time is incompatible. But still, it's a difficult enforcement because of the invisibility of the indicators that law enforcement would use to see that. So, like so many things, it presents its challenges.
Terry, were you going to say something?
Oh, I was just going to say that I think the new allowing electronics on the plane is actually going to cause some similar implementation issues. One of the interesting things, I don't remember which news source this was from, but this morning it looks like while you're allowed to have your e-reader, you're not actually allowed to have your laptop or anything bigger that pose a danger. For example, like if there was a bumpy takeoff, it could go flying across the plane and hit someone. I think that's actually going to be a really interesting airline. Like a book, I remember in law school, occasionally one of those big hulking books with me. And for our group, I think that book would be just as dangerous as the laptop, if not more dangerous.
Yeah, definitely.
It's this kind of old analog technology. So I think with anytime you try to regulate a new technology, there are always going to be this really practical implications.
All right, Evan, you've been, since we're on the topic of tech and cars, you've been considering self-driving cars and the legality. You have a post up on Internet Cases about that. Does any of this play into what we've been discussing?
Well, I'm sure it does. Again, this is probably one of those things I'd have to stop and think about. But yeah, I wrote up a post this past week that was what stirred me to talk about this issue was some new evidence that comes out showing how much safer self-driving cars are, and how it would eliminate so many traffic deaths. It would also be good for the environment because it would eliminate a lot of congestion in traffic patterns. And so there's all these wonderful social, societal, cultural benefits, human level benefits to self-driving cars. And so I started thinking about it and just crystallizing my thoughts here. And at a very basic level, there really are at least three main categories of challenges. There are the economic challenges to it. There are the cultural challenges to adopting self-driving cars. And then there are the legal challenges to it as well. So my post really was to present some of the questions that we would ask ourselves in considering, how to regulate self-driving cars, from a legal standpoint. And again, this is just at a very basic level. We talk to people, brilliant people like Ryan Kalo, who've made a whole career thinking about these types of issues. But it's nonetheless helpful to sort of lay these out. How do we? Should we adjust the speed limit, for example, if it's proven that self-driving cars can be safer? Should we be able to go faster? And how do we allocate risk if there's an accident? And what are the effects of that in insurance and the costs that there should be? And then one of the most intriguing issues, which we've talked about on the show several times before, is what is the responsibility, the liability risk of exposure to the manufacturers of these autonomous systems if there's an accident? Should the manufacturer be liable for those types of things? So yeah, I mean, the bringing it back to our current discussion about wearing Google Glass and the new FAA lifting of restrictions on devices like that. The technology allows us to place ourselves in certain contexts where the risk to us was not known before because of what the technology would afford us to do. And we've got to figure out how to make these rules that are fair and that strike a balance between innovation and giving the innovation room to grow and taking care of ourselves at a very essential level, our safety, and you're seeing that those things are in balance, and that's how to reasonably move forward into the future.
Well, we've obviously got a long way to go, given all those hurdles you just laid out, Evan. Before, the roads look very different than they do now, and cars drive themselves as the standard. But Larry, in that world, can you see why we would even need car insurance?
Well, I don't know if it would be insurance for the car or it'd be insurance for the road. Of course, in some ways, as my co-author in the book pointed out to me at some point, cars are really self-driving now, almost already. In many ways, there's much more about the car even than there was 10 years ago, that it does itself. The application of the brakes, is a good example of it. If you've got anti-locking brakes, the way the steering happens, of course, the backup cameras and everything. So in one ways, we're moving to it incrementally already. And then in the bigger picture, obviously the fully self-driving car, and then embedding the sensors in the road, that would be, part of it. It would basically everything would become intelligent in the system. And then it's not really clear, what are you insuring against, or who needs to do the insuring. I think what I always worry about, and I know you would all probably agree with this, is who's going to make those decisions, right? So we've got lawmakers who don't use the technology. We've got judges who don't use the technology. We've got, as we saw in the last example, we've got law enforcement officers who don't use the technology. They are, by default, the people who make the policy decisions about how to adapt our existing laws to new technologies. And that's really the cause of a lot of the unintended consequences we get when, the people making these decisions don't really understand the technology they're making the decisions about.
All right. Anybody else have any thoughts on planes, trains, automobiles, and technology? Now would be the time to chime in with them, because I'm about to shift gears a bit. No? Okay. Then this next story has to do with patents. So we're still a bit in a vein here with artificial intelligence and how it's changing the way that things traditionally have been done. There's a new company in Silicon Valley called Lex Machina that Mark Lemley and others from Stanford have created. And what it is heavy-duty data analysis applied to intellectual property and specifically patent cases. And it's a wonderful sounding tool that allows you, they take publicly available information and make it much more useful. They've gone through all kinds of effort to be able to crawl different public databases where legal decisions are made available. Then they've made sure that the data that they're getting out of there is parsed properly on their end, so that they actually have every case that's been decided since the early 2000s, I believe, that has to do with patent infringement, for example. And they have over 130,000 cases in the database, and they can tell you things like which lawyer has handled a particular issue before and has had success on that issue. They can tell you which judge has ruled in which way. The kind of local knowledge that you used to hire law firms for to tell you, if you're the client in trouble, help me understand what's going on here. And part of that is not just shaping your strategy in the case, but shaping that strategy with reference to information that the client wouldn't otherwise know. So this is definitely giving clients and lawyers a huge leg up in having that information. It's not cheap. I believe the subscription annually is $50,000 a year to be able to access this information. However, they are making it free for government agencies and academia. So one of the first things I thought when I read about Lex Machina was that thank goodness somebody did something nice for law students, because they've been having a rough time lately, crippling debt, no jobs when they get out. But now all of a sudden they are going to be able to access this very expensive and very useful database of information where the law firms that may want them to come work for them someday will otherwise have to pay a hefty fee. So, they'll have some kind of bargaining chip maybe if they can offer to do a little Lex Machina research for firms. So anyway, I just think this is a really fascinating development. Certainly, it's the kind of information that you would like to see across the board in the legal world. So maybe it will be a test case for parsing data in this way, not just in the patent infringement realm, but in many other areas too. Evan, what do you think? Are you signing up?
I can't quite yet afford the $50,000 per year subscription fee, but maybe next week. We'll see how this month goes. This is really neat. And first of all, this was one of the founders of this was Mark Lemley, right? One of the friends of Twill. So really neat to see technology being used this way, the application of law and technology. Wow, aren't those two things that we really love a lot? So, and it lends itself well, or the substrate of what's going on here lends itself well, the substrate being the law, the subject matter, lends itself well to the application of these technologies, because what's really happening at base here is the application of this technology to discern patterns in the complex systems in which patent litigation, other intellectual property infringement litigation is occurring. So it's really interesting to see that happen. I think it could be of extreme benefit for that particular subject matter, intellectual property litigation, infringement litigation like this. And as the technology becomes more advanced and the processing power of our systems becomes more advanced, the price ought to come down on things like this, and it'll become more widely available. At the same time, I don't know that it's necessarily something that would benefit every area of the practice of law. If I were to litigate a matter, at a purely local level, just dealing with state court judges and all that, that's certainly a matter more of who you know and what your familiarity is with the local customs and practices, and I don't know that we would need sophisticated technology like this to be able to do just as well in that type of scenario. But in any event, I just think this is a really fascinating use of the various technologies that are there, particularly the language processing of going through and looking at these large sets of documents and figuring out language patterns and ascribing meaning to the thousands, hundreds of thousands of maybe millions of pages of documents that comprise this data set. So it's encouraging to see technology used this way to improve the way that law is done.
Well, the flip side of the coin of my thinking, good news for law students is, and that law students would like it, is that judges would hate it. And that judges would look at this and go, well, you can try and find patterns in what I do all you like, but I independently review each case and I defy you to try and predict, what I'm going to do with a particular case that comes across my docket. Are they just kidding themselves, Larry? Do you think we're all just prone to being data crunched?
Yes, I think they're kidding themselves. Mm-hmm. The legal profession is notoriously, and some would say intentionally, obscure, right? I mean, we still have lawyers keeping the quill, pen, and ink people in business. It's the information that we've got is never particularly well organized. It's not normalized. It's not standardized. Judicial opinions, they're just text. The decision-making process is intentionally obscure. So I applaud any effort that tries to figure out a way to organize the unorganized nature of it. But in some ways, this is really the tip of an iceberg. The actual practice of law and the profession of law and the science of law is so undeveloped that it's as inefficient as is. Some might say it's an art, not a science. Obviously, the people behind this product think it's more of a science than people think, and I tend to agree with them. So I'm sure there's more of this kind of heavy-duty data crunching, number crunching that can be done and will be done as the computing power just gets cheaper and cheaper all the time, just throwing more stuff at it. And we'll find out. We'll see if judges actually can be predicted, or if outcomes can be decided by the use of computers. I tend to think that yes, we will find that these patterns are much deeper than anybody wants to think they are now.
So, Terry, you're loosely affiliated with the Cardozo School of Law, correct?
No, we are not actually affiliated with the Cardozo. We're affiliated with California Western School.
California Western. I'm sorry, I'm getting my my law schools confused. Yes. So, but you are part of that particular law school.
We are, and we don't do that much patent work at New Media Rights, but right when I was getting out of law school, I actually used Lex Machina quite a bit to do some research on trending and patent troll cases, and it just cut my research time in half. I cannot say enough good things about how useful it is for crunching data, and I'm working on a response to the green paper that came out, and I really wish there was a copyright version of Lex Machina right now, because I keep having to go and not only research myself, but ask my interns to catalog certain trends. And it's really a time-intensive process when you're using Westlaw or Lexis or even, God forbid, Pacer, which is very, very painful to use. The only downside I would see with something like Lex Machina is something that I've heard of certain Silicon Valley patent attorneys have started. You can actually look to see when your opposing counsel's deadlines are, and some of them have started to encourage, to kind of surreptitiously file when they realize, like, oh, you have 5 deadlines today, I'm going to file something today. Just
that's the time to seek a TRO, isn't it?
Yeah, definitely.
It's perfect. Yeah.
So Terry's covered. She's part of an academic institution. Evan, arguably you and I are covered because they're going to make it free of charge to media outlets.
Oh, yeah, of course we're the media. Sure.
Yes.
Sure. Yeah.
So
Look us up,
we'll have to talk to Professor Lemley about that and see exactly who, we can get into the whole discussion of what constitutes journalism again, I suppose, or media.
There you go.
There we go. If that's not media, I don't know what is.
This whole idea about finding patterns in the processes of the judicial process is really interesting. And in hearkening what you said, Larry, would judges just be fooling themselves? I mean, it's not a new thing to try to look at patterns of behavior among courts. I remember when I was in law school, this may be telling. There was, my law school was, getting rid of some books from the library. And this was one of the books, like on the, here, take these books, they're free, we're getting rid of them. But I got it and I actually looked through it. It was a book called Empirical Theories About Courts. And I looked it up on Amazon. It's available here. It goes all the way back into the 1980s. But this whole process of really, and I trust that the whole effort predates the 80s. I mean, that seems like it'd be a fairly recent vintage. I imagine for as long as people have been interested in statistics and looking at things and examining things empirically, which I guess has been since ancient Greece, at least. We've tried to apply these principles to courts as well. So there's only something to be gained and nothing to be lost from at least examining what these patterns are, regardless of whether the judge is going to say in each individual situation it's going to be a fact-specific determination based on what the law is. That law is always going to be relatively static. Look, there's the concept of stare decisis, looking back at what's there. That is the same etymology of being static. So there's a certain flexibility that comes that are given to us from the facts, but the law is what provides something that is static, and it's only natural that there could be some science done about this.
Yeah, there used to be, years and years ago, I worked with a firm that did, essentially for juries, they did a lot of work with trying to predict jury behavior and jury selection criteria. And it's not surprising that firms like that were started and run not by lawyers, but by clinical psychologists. Because they, that's their science. They believe that behaviors can be predicted and that there's lots of ways in which we signal things that are not obvious or even to ourselves. And I suspect that, in some ways, what this is really doing is kind of updating the process of, shadow juries and jury prediction and just applying it to other human beings like judges and other lawyers.
Yeah, that is a fascinating point. And I can definitely, I'm joking about Evan and I being able to skirt the fee requirement. Larry, you write for more media organizations than I can even keep track of. And I can definitely see this being invaluable to people trying to have a larger understanding of trends, and really, write a detailed article about what is not just what is likely to happen, but what has happened and how the past can perhaps help us look into the future. So hopefully people will hear about this and make use of it, and we'll see more of this kind of thing in both in the practice and in folks trying to analyze and understand legal trends. Any final thoughts about Lex Machina? Going. I'm going to go ahead and make Law Machine our first MCLE passphrase of this episode of This Week in Law. If you are listening to the show and you're a lawyer and you must get continuing legal education credit, as I think all of us in the United States have to do, then head on over to our wiki at wiki.twit.tv, and we have information about all the 50 states of the United States and how you might get credit in your jurisdiction for listening to or watching the show. And we put these terms in case anybody wants to confirm, you're not just on the honor system like people on airplanes with their devices. We'll actually give you these terms to be able to say, look, I can show you that I listened to the show because they hide these secret voids in the show. So Law Machine is the first one for this episode. Let us move on to talk about, we've been talking about policy kind of the whole time, but let's do it officially now. We've got a bunch of acts that are pending. The USA Freedom Act, the Innovation Act, the Jobs Act was passed some time ago, but is just now starting to show us what it's going to do for the country. Why don't we start there, Larry, since you wrote about that this week, the Jobs Act and crowdfunding. How is the Jobs Act now having what you would call its big bang moment?
So this is great. The Jobs Act, as you may remember, this was passed in 2012, and it was aimed at trying to figure out ways to encourage startups and kind of, jumpstart the U.S. economy out of the recession. So there were many, many provisions in there that were trying to encourage entrepreneurship. And one of them was the idea that you could do, if you were a startup, being able to do small amount of fundraising from kind of non-traditional investors, people who didn't have the usual criteria. And the Security and Exchange Commission was directed by the law to develop new rules that would allow startups to raise modest amounts of money and also to be able to use the same kind of a model, let's say, as a Kickstarter or Indiegogo that would allow you to raise that money from people who were not typical or traditional investors, but would be able to contribute small amounts of money. For some reason, the SEC delayed this for over a year, and finally this week they issued the proposed rules in a 600-page document that asked a lot of questions. They're clearly looking for industry feedback before they put the rules into effect. But essentially, it's a 90-day period. So essentially, the rules could go into effect sometime early next year, and it would allow either existing registered broker-dealers or something new they're calling these financial portals to, with a sort of minimal amount of reporting and a minimal amount of qualification ahead of time, do effectively what Kickstarter does, but in a fundraising way that allows you to sell equity in the company. If you've ever used Kickstarter, you know that it's essentially you're making a donation to the project. You're going to get some premiums or rewards in exchange for that, but you don't get any ownership interest, obviously, in the product or service or the project organizer's company or whatever it is the entity is. In effect, once these rules go live, that's what you'll be able to do. If you're a startup, You'll be able, I think it's $1 million at a time over any 12-month period. You would be able to use this highly shortcut way of doing fundraising to sell equity without going through kind of, the very expensive and very elaborate process, both from the government standpoint and the investment bank standpoint or venture capital. And you'd be able to raise the money from individuals. There's pretty significant limits on, individuals can only invest, I think it's 10% of their net worth and again in a 12-month period of time through these new mechanisms. But it will bring a lot of new people into the investing world. It'll allow startups to get money, a small amount of money, without having to kind of use the traditional capital market structures of angels and venture capitalists and financial banks, private equity, and so on. So we'll see, of course, how it actually plays out, but it could have tremendously disruptive impact on, kind of what's at the heart of Silicon Valley, the whole financing machinery that we have here. It works very well, but many people think it's just not democratic enough, or it only really works for large things. If you want to do something more like a Kickstarter, you couldn't do it up until now. And I should say, I keep mentioning Kickstarter. The company was quite clear with me after the article ran to say their policy is they are not intending to change how they do project fundraising. They will not be selling equity through Kickstarter. They're not saying it's a bad idea, but it's just not their model, and it's not how they intend to go forward.
Somebody will do that, right?
Yeah, there's already a trade association that's been sprung up of people ready to sort of jump in here. And in fact, outside the U.S., this already happens. In the U.K., individuals are allowed to contribute, buy equity essentially through these kinds of websites. So it could be traditional, they say, it could be existing people who do equity fundraising, but more likely what we'll see are some startups that will build essentially around compliance with the new SEC rules once they go into effect. And, they may be people we know, they may be people we don't know, but in some ways there'll be a whole new set of startups just to implement these new rules.
Evan, do you feel like this is a big deal to us because we pay attention to small technology companies and companies that might want to raise money in this way? Does this matter much? Will the average investor even know that this is something that's available and out there?
Well, I think they will. Because I pay attention to what's going on in the technology space, and it's as a secondary interest that I see what's going on in this space, when it comes to investing and venture capital and angel investing and all of this stuff. So, if it's a big deal to me, it seems like it would be a big deal to the world at large. So I have no reason to think that this is something that's segmented or somehow just is only going to interest a small portion of the population. And then I'll look to what smart people like Larry Downs are saying about this. If this is a big bang kind of moment, well, then I'm going to take his word for it and recognize that it is significant on a pretty large scale with all this stuff. I mean, what do you think? I mean, do you think it's something more narrow?
I don't know. I guess I'm going to have to, let it play out a bit. It strikes me that people who have a lot of money to invest already have ways that they like to go about doing that. People who have small amounts of money to invest even, have ways that they go about doing that now or can do it. That certainly if this is marketed right, companies are going to be able to attract new kinds of investors. And, we could well see, as Larry is pointing out, the venture capital and other infrastructure that has provided the traditional funding, having a layer of competition that they've never had before. Larry, do you think that they're poised and ready to respond to that?
No, no, I don't think they take this very seriously yet, and I suspect it won't be until it happens. That really is kind of, in some ways, the story of Kickstarters. Well, no one really thought this would go anywhere. I think they're now close to hitting $1 billion in total kind of, pledged amounts for projects that actually completed in a very short amount of time. And I think one of the lessons to learn here is the best way to do marketing for a new product or service, the best way to build a customer base who's going to become your missionaries and your outside sources, is to involve them very, very early on. And so in some ways what Kickstarter does is involves customers in the design and the initial launch of new products before they even exist. Well, imagine, how much invested equity you have of the kind of the social nature if you're the person who bought, helped them get their money to build the first production run of a certain product or service. You're going to be an ambassador for that product or service that's more valuable than any kind of traditional marketing or advertising could ever be. So take it to the next level now and say, what if you're actually invested literally in the enterprise? You own a tiny piece of equity in it. You're going to be even a better ambassador for that product or service on your social networks, with your immediate networks, and so on. I think that's where the disruption will come from. Is in some ways it's a new way of doing marketing and sales that it can be extraordinarily powerful, as we've already seen.
Yeah, I could definitely see that. I could also see the financial advising industry getting a nice kick from this. Because there are going to be so many investment opportunities out there that people aren't going to necessarily be comfortable with making a judgment call on themselves. But if you're a savvy financial advisor, and you're not just looking at, the traditional investment vehicles, but looking at these Jobs Act fundable kinds of entities, on the one hand, you could get your clients a nice leg up if you're very smart about what's going to be a good call, but you could also be opening yourself up to liability. Obviously the financial advisors are good at shielding themselves from that kind of thing, but this is a whole new ball of wax, and people seem to be very concerned about the fraud ramifications of having funding eased up in this way.
Yeah, and of course there are safe harbors built into the proposed rules that you have, again, minimum reporting requirements both for before and after you do the fundraising. But that's right. Obviously, every startup investment is by definition a high risk investment. The SEC is trying to balance the need to protect investors, but also to open up the process in a way that the industry, under the guise of protecting small investors, maybe also was protecting themselves from competition. So we'll find out how that balance works. But I think ultimately it's a good thing.
Terry, you work with a lot of small creators who could probably benefit from these new rules and fundraising opportunities. Do you think your clients will be taking advantage?
I think some of them will. We do get a lot of questions about getting into Kickstarter and how complicated is it and what's really the focus. I think a lot of really small entrepreneurs that we see don't necessarily understand how important the marketing component is. But I think as we see more and more entrepreneurs understand how the process works, how it really is about that publicity push and that marketing push to get people invested in the product, I could see quite a few entrepreneurs that we've worked with taking advantage of something like this.
Okay, let's talk about a couple of other acts, the Jobs Act having come along a while ago. We have a couple that are pending now under consideration. The Innovation Act, which addresses the issue of patent trolling. Evan, do you think this is going to be the silver bullet?
Well, gosh, if you ask it that way, then the answer's got to be no. There's always limitations to these things. It's not perfect, but there are definitely some good things to this that would counteract patent trolling. If this is passed, and from what I see, it looks like it stands as good of a chance or better than any other similar legislation that's been enacted in the future. One of the good things is the bigger chance that the loser pays, to make it more, to give more trepidation to the plaintiffs who would file lawsuits and end up losing. Patent trolls end up losing. That's one thing that's promising that ought to do something to curb that a bit. Heightened pleading requirements actually requiring the patent plaintiff to articulate how its patent is being infringed. There were a couple of other good things. I was just kind of going by memory on those things there. But yeah, this is it's a step in the right direction, and it recognizes the scourge that patent trolling is. And of course, I can't speak to it as emphatically as Lee Cheng did a few weeks ago here on the show. That guy does not like patent trolls, so he would say that anything that you could do to curb patent trolling is a good thing. What this does not do is give much of a disincentive for non-practicing entities to send shakedown letters to lawyer or to companies. That there's really no way that the legislation could do much about that. But once lawsuits are filed, frivolous lawsuits are filed, this does provide some mechanisms to bring that back closer to a sensible level. So it's encouraging.
All right, Larry, are you paying attention to this one?
I am, and I have to say, when I was going through the show rundown, Denise, I was looking at all these different things, and every time I made notes to myself, I thought, oh God, I'm going to be such a bummer on the show because I'm going to have to bring everything down. I have to start by saying this legislation has no chance of passage. I commend Congressman Goodlatte and the Judiciary Committee for putting it together. The fact of the matter is, I was in Washington most recently the week that the shutdown began, and I can tell you that no substantive legislation is going to pass in this Congress until there is a budget deal, long-term budget deal, even if it has, strong bipartisan support, which this bill does. There's just going to be no substantive legislation on any topic that's going to make any progress. And in particularly this one, because in fact, bipartisan support is one thing. It doesn't have full industry support. There are already some industry groups that have come out against it. That would normally be enough to kill substantive legislation, but in the particular climate the Congress is in right now, that's just icing on the cake. So I agree that, of course, the patent troll issue is a bad one. This bill does a lot, although it doesn't do everything we would like it to do. But the reality is, I just can't see patent legislation. I can't see immigration legislation, which is also very important to the high-tech community. Much as I wish that were not the case, my reading of the mood in Washington is that substantive legislation just has no chance right now.
Well, that is a downer.
It is.
Yeah.
And that's not even factoring in the Lex Machina lobbying that's going to happen, because if patent trolling goes away, they're going to have such a smaller database for people to search. Terry, what do you think?
If this law had a chance of being passed, which it sounds like it probably doesn't at this time, it has some really great features that I think are a huge step forward from things like the SHIELD Act, especially the consumer suit exception, and really some of the transparency about patent ownership. But I do think, since we do see a lot of those small entrepreneurs who do see the settlement letters, ultimately, I think for a lot of them, that settlement letter and that demand letter of you've got to stop what you're doing and give us lots of money and then we'll go away. Those letters are terrifying, especially for individuals or really small companies to see. And I really think that if we could get something that would help that problem, to have some sort of standard for having these letters be sent, I think that would actually do a lot to destroy the patent troll business model. But this law doesn't do it. I really haven't seen a good legislative solution for that one yet.
All right. Well, even if it doesn't pass in this term, maybe it'll be a model for something in the future. Terry, I should have asked Art this last week, but it didn't occur to me. So I'm going to ask you. We talked a bit about the small claims copyright court that's under consideration by the Copyright Office and Maria Palante and her lengthy report on establishing that. I know it's something that New Media Rights has been advocating for. I'm wondering if you think a similar kind of situation on the patent side makes any sense.
Now, this is something I really have mixed feelings about. I think if copyright law is complicated for the average individual to understand, I do believe that the copyright system will work since it can be broken down. I think patent law is decidedly more complex. And it's much, much harder to break down for the average person, okay, what are the elements of a patent suit? So I don't know if these small claims would work. I think if we got a functioning copyright small claim system and we got some really great patent attorneys sort of on board and working out a new system for patent, it could happen. But I'm a little bit more skeptical of it for patent than for copyright. And I also think that for copyright, because we have so many more people creating, especially a lot of creative works that fall under copyright and not things like patent or trademark necessarily, I think the need is greatest there. And I think the thing we're going to see with the copyright small claims court is once it gets established, I just see like it growing and growing and growing quite a bit, since I think there really is a need for this. So I think maybe once we get to the point where we have an established small claims court for copyright law, maybe we could add patents, but I think it would have to be a very deliberate process, and it might even have to be a system that kind of runs parallel to it but isn't actually within the copyright small claims system.
Okay, great. That makes perfect sense to me. And it's interesting to think about changing the way that smaller disputes get resolved in both those arenas. Let's look at the USA Freedom Act. Larry, I mean, so even though this looks like a great way of reforming the Patriot Act and making sure that all that metadata surrounding our phone calls can't be gathered, this isn't going to go anywhere either then?
Oh my God, there's so much hypocrisy going on right now on this topic. It's unbelievable to try to listen to this with a straight face. There is almost nothing, I think, that the Edward Snowden revelations have told us that was not already known, discussed in Congress during the renewal and the enhancement of both the Patriot Act and the FISA Act just a few years ago. I was writing about it, but more importantly, people like Julian Sanchez at the Cato Institute was, every day saying, this is what they're doing. This is the threat to civil liberties. And, at that particular moment, Congress was saying there is no higher priority than security. And we're willing to throw out, as much of the Bill of Rights as they possibly could and could get away with. We knew that the metadata collection was happening. We didn't have actual FISA orders in front of us to look at, but there was nothing that was surprising to me so far in anything that's come out of these revelations. And now to hear the very same members of Congress saying, we don't understand, how did the balance between freedom and security get so out of whack? This just, we weren't here, so it must have been somebody else who did this. These are the very same people who were pushing for strengthening the Patriot Act and strengthening FISA when they both came up for renewal. Now, of course, because of the pressure they're under, they're saying the exact opposite. What they'll actually do, I don't know if you saw some of the deliberations about the changes to the law are happening in secret. That's a nice touch. So, they won't even deliberate openly about the need for open deliberation and transparency in the way that it's done. I, again, have to be the downer here and say, I don't expect any substantive changes to substances. I should say, I'll caveat that with, if any more revelations that are really juicy, that do tell us something we didn't know, as those continue to come out from Greenwald and from Snowden and anybody else that's leaking the stuff, if it gets even worse, and I frankly thought this story would have ended a while ago, and it's lasted longer than I thought, so that's a good thing. But pending anything really dramatic being revealed, I don't expect Congress will really, they'll talk about this, of course, but they won't actually change the law in this immediate future.
Well, it's got a good acronym anyway. Let me just read it out because it's worth paying attention to.
This must have taken as much time as actually drafting the legislation.
It must have. Wait, now I can't find it.
Patriot Act is an acronym also.
That
took them a long time. So
here it is.
Like, what do you want, freedom or you want patriotism? You have to choose.
Here it is. Uniting and strengthening America by fulfilling rights and ending eavesdropping, dragnet collection, and online monitoring act, condensed down to USA Freedom.
I had to skip over some words for that, right?
Yes, they did.
Yeah, so it's USA Freedom or USA Patriot. You decide which one you want.
Yes. Evan, do you think this is, as Larry is suggesting, sort of a PR gloss on the legislators' past votes?
Yeah, I certainly do now after hearing what Larry has to say about it. I mean, I came at it a little bit skeptical to begin with. I mean, I certainly don't have the insight as to what's going on in Washington and the things that are motivating legislators. But it kind of smacks of well, it certainly is a situation where because there's so much public sentiment about this, is such a sensitive issue, and people are. I guess people are still upset about it. Well, it was June when the Ed Snowden stuff broke, and we've had plenty of other stuff to talk about between then. I mean, the world is changing. If you go to CNN.com and they're talking about Benghazi, Fox News has been talking about Benghazi for a year and a half, or a little over a year. But in any event, there's plenty of stuff for us to have been concerned about in the last few months, and so that even though there are other things, this is still of critical importance, and it does have some currency for legislators to at least give the appearance that they're doing something about it. So other than that, what Larry said.
All right. Terry, any thoughts on the USA Freedom Act?
I mean, most of what I have to say amounts to what Larry said. But I mean, if we do get it passed, even if it wasn't necessarily coming from the best place, even if this is more of a PR move, it would be nice to have some of the transparency measures that are in the wonderfully acronym named USA Freedom Act. It would be nice to have that transparency and allow for companies to send out letters and actually disclose, like, oh, yes, we're getting all of these requests, and here are exactly the requests we're getting from the government for your information. That would be really nice, even if it's mostly seems to be coming from let's try to pass over some of this bad press and put out a new law.
Okay, well, talking about things that may not get done in Washington, one thing that did get done is Tom Wheeler, who we mentioned when we had Susan Crawford on the show. We mentioned how his nomination was blocked temporarily by Senator Ted Cruz, until he gave a statement on campaign finance disclosures. The statement that he ultimately gave was that this wasn't going to be a high priority for the FCC. So with that out of the way, Tom Wheeler was just confirmed to head the FCC. So that's not a downer, right, Larry?
That's right. I don't know if I'm thrilled, but I'm very happy that the FCC will have a permanent chairman again after 6 months of operating with an interim chairman who did a fine job. Commissioner Clyburn, did as much as she could without actually being a fully ordained chairman. But yes, the FCC has some really big things on its plate, and it desperately needed someone at the helm. And I think Wheeler is a really good choice for the job. But now the hard work really begins. The couple things we're mentioning that he's going to have to deal with immediately. One is the spectrum auctions for the over-the-air TV broadcasting spectrum. This is called the voluntary incentive auctions. It was also part of the Jobs Act, and it has gone. The design of these auctions is very, very complicated, and it's gone pretty much off the rails even before former Chairman Janikowski left the agency. It looks now like, at its current pace, it's going to be a long way away and may not work at all because the broadcasters may not actually offer any spectrum to auction and share in the proceeds. So that's got to be fixed. The net neutrality rules, I'm sure you talked about this with Professor Crawford last week. The court, of course, we don't know when the D.C. Circuit will rule, but from a legal standpoint, it didn't really look like there was a very strong case from the FCC side. And if they do get declared to have been, outside of their jurisdiction to pass, that could restart the whole net neutrality fight. And of course, the last time that happened, the FCC was almost completely distracted by that for over a year. Not really much else happened. Not really other business happened. Because of the problem with the spectrum auctions and the lack of any available spectrum for the FCC to make available for mobile broadband, it's almost certain that there will be more mergers and more spectrum deals happening among the existing wireless carriers. And so That takes up a lot of resource as well. Those mergers get very complicated, and the FCC and both the FCC and Department of Justice have to approve them on slightly different grounds. So that is, there aren't any pending right now, but there likely will be more very soon. So I want to just, I held up a visual aid before. Let me hold up another one. If Chairman Wheeler is watching on his first day, this is what I recommend he do, is pick up the National Broadband Plan that the FCC published in 2010, dust it off and read it, because in fact the agenda that it gave for everything, for the spectrum auctions, for competition policy, for mergers, for accelerating the retirement of the analog copper phone network that people are cutting the cord to. All these things are in that spectrum, in the National Broadband Plan, and he would do very well to use that as a sort of a work plan for the first year or two, maybe, of his administration. And hopefully, since it was published by the FCC, he can get a copy.
Well, I'm sure he'll do that, Larry, because my secret theory is he's been paying attention to all your writings on Big Bang disruption and crowdfunding and how venture capital's, getting its hat handed to it. And so he thought it was time to get out of that field, start doing something else with his life, such as chairing the FCC. Yeah. So, well, Evan, any thoughts?
We need that leadership now.
Yes. Definitely. All kidding aside. Evan, any thoughts on his confirmation?
Oh, nothing other than just to throw stones at, he's obviously an Obama insider, so you can tell that Obama was raised in Chicago politics, but that's nothing that's, nothing that's new. So seems like a good guy.
Yes, your politics are showing right now. Terry?
Not really much to add here other than the fact that it'll be interesting to see what he does. And I think there'll be more to comment on when he's actually done something other than be confirmed.
All right. Yes, indeed. And he seems, he's at least from, the writings hailing his confirmation that the people from all around industry and politics are optimistic about his chairmanship and willing to give him a chance. So that's a good way to start off, I would think. Larry, let's touch real briefly on, you were just on a panel comparing DC and San Francisco called A Clash of Visions for Tech Policy. In a nutshell, can you tell us any interesting insights or nuggets that you all came up with?
Yeah, sure. So this is an ongoing conversation, I think. And, one of the interesting things, and we just talked about it briefly when we were talking about the patent reform bill, is when it comes to technology policy, and particularly having to do with a kind of, innovation and disruptive technology, there often is not a Republican-Democrat split. It's not really partisan in that way. It's sort of much more splits along kind of old thinking, new thinking. And so you often do find liberals and conservatives, you find sort of libertarians and progressives sort of on the same page on a lot of these issues. And the panel we had included, someone who describes themselves as a very ultra-libertarian, someone who describes themselves as a liberal Democrat. And we really didn't find very much to disagree about. We understand that I think the main thing we agree on is that the reason that we have so many of these conflicts and collisions when it comes to new technology and the law is that the pace of innovation, particularly for information technology, is driven by Moore's law. And that, something that gets faster, it accelerates, it doubles, and so on. And so innovation just gets better and cheaper and faster all the time when it comes to a lot of technologies. But for, I think, very good reasons, the way legal systems are designed is that they, at best, stay at the same speed, and that's a very slow and deliberative speed. And what we all agreed was that the reason we have these conflicts, and we'll have more of them as more activity moves into digital space, is that the old law can't keep up. And there's no solution to that problem. I think that what we were talking about from a tactical standpoint is how could Silicon Valley or how could San Francisco or innovators more broadly speaking, how can they do a better job of engaging with legislators and regulators at the federal, and the state, and even at the international level, so that the accidents that do happen, don't have quite so much collateral damage?
Well, that sounds good. And yes, I'm glad to hear that it still seems like party lines can break down around these tech policy issues, and that it's more a question of where your thinking is and how it's been shaped, where the differences can arise. Let's move along to something fascinating that Evan pointed me towards earlier this week. And maybe it's something the USA Freedom Act might be able to address or not, but it's on the privacy front. Evan, GPS bullets?
Yeah, isn't this crazy? And this comes from, this is kind of weird. I saw the story on Geek Press. I think that's where it was. And it was a story actually from an Australian source, but it was what some cops in Iowa are doing. So there you go. Little bullets that contain GPS trackers in them. The cops can shoot it at the car and embed it in the car and then just sit back and watch where it goes. Pretty crazy, huh? So, yeah. It seems to solve some real problems. Clearly the public safety issue that's addressed by this is if there don't have to be all these high-speed chases, people are safe. How many umpteen people die every year as collateral damage in police chases? It'd be nice if that figure could go away. Naturally, we since we see things in a law and technology lens, what I thought, I was like, oh, what's the Fourth Amendment issue with this? How does this relate to, how could it tie in with the Jones case, which came out in January of 2012, which held that it was a search. Got to be careful with articulating the holding because there's some nuance to it. It was a search for the cops to affix a GPS device onto the guy's car and then sit back and watch where he went for the next 30 days to deal drugs. So with this, it kind of presents a different angle to all that. I think the way that this would be lawful in most instances is under the exigent circumstances doctrine under the Fourth Amendment. You don't need a warrant to conduct a search if there are exigent circumstances. So if the facts, and that is that the risk that the evidence is going to be destroyed or the suspect is going to get away or whatever you have here, if there's a high-speed chase going on and then there's the facts show that without this the evidence would be lost, there's a better chance that this would survive Fourth Amendment scrutiny than surreptitiously sneaking onto the premises to put a GPS, or I guess you wouldn't have to sneak onto the premises, but surreptitiously placing the GPS device on a car. So some interesting things to think about. Clearly, these issues aren't teed up yet. We don't have a defendant challenging a conviction on the use of this technology, but sitting here in our armchairs, we can think about how these issues would play out. So some interesting facts to give us some discussion here.
Is the purpose of the bullet to install the tracker, or is the bullet serving the traditional bullet purpose of, you're having a shootout with this person?
These are special.
The GPS is just a side effect.
No, these are special. I don't think these are intended to harm the suspect. That their sole purpose is to actually install the device. And I haven't seen a picture or a diagram or anything of how this is supposed to work, but I got this impression. It's kind of like Knight Rider-ish. I envisioned it coming out of this little compartment and a little firearm raising up and then going and affixing the GPS tracker. But they're relatively expensive, a few $1,000s to equip every car. And I think every time you shoot one of these things, there's $500 going right there. So it's it's a very specialized technology for this very purpose, which seems like it would have some great benefit to public safety.
Larry, do you agree with Evan that this kind of use of a GPS device might have a better chance of passing constitutional muster than simply, slapping a tracker on a car and watching where it goes due to the exigent circumstances?
Right. I think Evan hit it right on the nail of the head. I mean, a lot of people don't understand is that the Fourth Amendment requirement of a warrant to do a search and seizure is not in any way, shape, or form absolute, and courts have crafted all sorts of exceptions. The exigent circumstances is one, the plain view doctrine is another, the sort of stop and frisk, special rule, you can search a car incident to an arrest, all these other exceptions to what's called the exclusionary rule, which is the way in which if your Fourth Amendment rights were violated, you get to suppress the evidence. There are lots of exceptions to those. This one, we'll see when it's tested, but it does sound like a pretty straightforward exigent circumstances exception. So I don't think you'd get very far with a Fourth Amendment challenge, but I also expect there will be Fourth Amendment challenges to it. And of course, as Evan says, it's very expensive now. But again, as I just said a moment ago, you can always count on these kinds of technologies to get cheaper and better over time. So if a GPS tracker device costs $500 now to shoot out of a cannon, it'll cost $200 to shoot it out of a cannon 12 months from now. It'll cost $50 to shoot it out of a cannon 2 years from now. And by the time it probably is, the same as your, the cost of a cell phone, at least the raw materials, we'll have embedded sensors in the road anyway, so that the wireless antenna in your tires, which already exists, will be communicating with the road, and you won't need to shoot the tracker at all.
Right, and we're full circle back to Evan's post about self-driving cars and how much data they're going to gather about us and whether we're cool with that. So there we go. Whether it's bullet-driven or in your car, I guess finding your way into police databases is inevitable in the future. Let's move on to something on the copyright front that I'm interested to ask Terry about. So over at Copy Hype, Terry Hart, who we've had on the show before, is taking Fred von Lohman to task. Fred, of course, is the legal director for copyright at Google, formerly of EFF. And Fred apparently has been giving a talk about copyright and reform. And there are a lot of people in Washington that are paying attention to that issue right now. And one of Fred's points per the coverage of these talks that have made their way out into the world. It was live tweeted, for example, by Yale's Information Society Project, is that copyright law is no longer incentivizing in the way that it was designed to, that people are not incentivized by the fact that they have a copyright in something when they post a picture to Instagram or, otherwise engage in the sort of social sharing that we see becoming more and more common. So Terry takes issue with that and says that, be that as it may, maybe copyright is not the primary motive for urging people to share, but people still care a great deal about how their works are disseminated. So once they've posted to Instagram, what can then be done with the work? And they're happy to have copyrights that they can look to and say, hey, that's my thing that I put there, and you're going to have to respect my rights and wishes when it comes to reusing it in ways that I might not approve of. So, Terry, all this seems sort of up your alley and what media rights concerns itself with. What do you think of all this?
I have a few base problems with the article at hand. I think the article misses the boat entirely by saying, it has to be one or the other. Copyright either has to incentivize production versus incentivizing people having a way to have control over their own works. I don't think it's an either or. I think copyright is designed to do both. I'm also a little bit hesitant to rely on live tweets as a way of, setting up an article and saying, oh, this person said that. It's a little bit like those stories you see where Fox News or CNN will take a tweet and it turns out the tweet wasn't actually quite what the person said. So I didn't hear the speech or find a recording, but just offhand, I'm a little bit skeptical.
I gotcha.
I do think that it is important that, yes, users should be able to control their copyrighted works online, but I think those tools are already out there. And I don't think anyone is making the argument that we should get rid of copyright as a whole and just let information be free. I there is a very small subset that's making that argument, but I don't think that's where the larger copyright reform is really moving. That's not the direction we're pushing. Where a lot of the directions we're pushing is to kind of narrow those laws and give consumers, not only more control over how their information is disseminated online and how they can enforce those rights. A lot of those discussions are happening right now, especially in our response to the USPTO and U.S. Department of Commerce green paper that got put out this summer about copyright reform. So I think those arguments are being made about how users can better control their work. But I do think, hand in hand, as we're making those reforms, we really do need to think about the incentives of copyright and how people really aren't incentivized. Like, for instance, I'm not going to not post something to Instagram because my great-great-grandchildren won't be able to benefit from it. That's just not something that really people are thinking about when they're posting.
Larry, we were referencing the green paper that is out there on copyright reform. Is this depressingly another thing that Washington's just not going to pay attention to at the current juncture?
Absolutely. There is zero chance of significant copyright reform. I don't know how far in the future I'd be willing to go, but certainly in the next 12 to 24 months, not a hope of anything happening out of Congress. But I agree with what Terry was saying. The bigger issues aren't about these sort of somewhat philosophical questions about how the system is structured and how the incentives work. The bigger issues are really easier to fix, except no one's going to fix them. But we understand that for certain kinds of work, copyright is just too long, and for certain kinds of work, civil and criminal sanctions we've got are too severe, and the ability to use civil forfeiture law here as elsewhere is too generous for law enforcement. That's what's causing the heartburn now around copyright for new media and for new technologies. Those would be, easy to fix in the sense of you could write the fixes relatively easy, but getting them through Congress is just impossible.
All right. Well, I'm just going to have to cheer myself up by making speeding GPS bullet our second MCLA passphrase for this episode of This Week in Law. And by moving on to our resource and tip of the week. Terry, you actually pointed me toward the resource, and then actually in a sidebar to the article about Lex Machina, this company is referenced as well. I guess it is a startup out of Stanford Law School called Ravel, and it's a new kind of legal search that does some really interesting graphical representations of search results, among other things. Do you use this regularly? Ravel seems like a really cool tool. So and it's free and available online at ravellaw.com. So I encourage people to check it out. It enables you to select your jurisdiction. It does this really cool kind of sort of a web net graphical. It's hard to describe. You need to go try it yourself. Representation of how cases and keywords relate to each other. So it's a cool new tool that's out there. If you haven't tried it, go check out ravellaw.com and see if it helps you find the information that you're looking for. And then our tip of the week is to tag carefully. And that is because sites' terms of service may not be entirely intuitive as to what's going to be banned and what's not. There's an article over at Ars Technica about how the tag food orgasm is banned on Instagram, but guns for sale is not. Also, iPhone appears to be banned on Instagram. So this is all, up to the sites, what they're going to enable users to do and not do. And maybe sometimes things are slipping through the cracks. Maybe sometimes it's a policy decision. But here, let's see. The update on food orgasm I should read. While the hashtag food orgasm appeared on the original banned tags list, Instagram appears to have re-sanctioned it. Likewise, thinspo has been reformed into a searchable tag with an interstitial advisory warning. So tag carefully out there, folks. You don't know if you're going to be running afoul of some content policy or not. Any thoughts on this, Evan?
Well, I mean, it's a moving target. I mean, because these things are particularized and it requires some judgment call on the platform. But yeah, I mean, as far as the tip or the resource aspect, well, yeah, we're in the tip of the week here. Sure, I mean, you gotta think through the consequences, and by that I mean the effects of how you're trying to make your content available here. So.
Yes, if you're tagging something guns for sale, you have other legal considerations that hopefully are crossing your mind aside from violating Instagram's or some other site's terms of service. Right. All right. Well, we have come to the end of our discussion, sadly enough. It's been, a downer from time to time, I got to admit, Larry, but it's always an upper to have you on the show. It's always very fun and interesting and lighthearted about serious issues. So we appreciate your joining us once again.
Well, I thank you, and I apologize. And I promise next time I'm on, which I believe I'll be back in December, I'll only talk about happy subjects.
The happy episode with Larry Downs. We'll just have little holiday elves dancing across, and
that's the eggnog episode, hopefully.
Yes, hopefully. I think actually that is our last episode before the holiday break, so it may well be the eggnog episode. So we're looking forward to seeing you again then. What else is on your plate, Larry? Aside from you've got the book coming out, it's Galley is done and should be available hopefully right before you come on again. Anything else?
I hope so. Well, I'm going to be spending the rest of the year in sort of book promotion mode, trying to get pre-orders up. That's apparently very important for the bestseller list. We have high aspirations, so buy books, buy them early.
Early and often, for sure. A wonderful holiday gift for all of those out there interested in disrupting current business models. Let's see. Any speaking coming up that we should know about?
No, I don't think so. I think the next speaking I'll be doing will be at CES in Las Vegas. I'll be there moderating a panel on the Internet of Things, and then we'll be actually doing an interview and book signing on the second day on January 7th. Very cool.
All right, Evan, it's been great chatting with you again, as usual.
Yeah, the same. Glad to be back this week. Missed you last week. So, I've really enjoyed this conversation. Terry, very nice to meet you. And Larry, very, very nice to talk to you again. Really have enjoyed it.
Yes, Terry Karabonic. It's been really great chatting with you. Anything on the new media rights front that we should be aware of?
We do have a couple of things. If anyone's going to the IP Institute up in Berkeley, Art will be speaking on a panel. And as we are proud to announce going to South by Southwest this year for a panel.
Great.
And I'd say the big last thing for new media rights that I always like to say is we are entirely independently funded, and we do rely on individual donors and our partners to keep our doors open and helping these, hundreds of individuals every year with technical law problems and copyright problems and things like that. And any support is always appreciated, and we love being able to provide those services to creators that really can't afford the $500 an hour copyright attorney.
Yes, and for more information on new media rights, head over to newmediarights.org. You'll see how you can donate and what they're all about. And I will just go ahead and plug, as we did last week, amazing resources for computer-related creators over there. If you're involved in creating any kind of online or digital media and you're worried at all about the legal ramifications of what you're doing, New Media Rights is a great place to start because they have guides to just about everything. So go check that out. And Terry, thanks so much once again for joining us.
Thank you for having me on. It's been a lot of fun.
It has been fun. And if you've joined us today at 11 o'clock Pacific time, 1800 UTC, congratulations. You watched us record this show live with all of our Skype issues in tow. If you like the more cleaned up version of the show, of course, you can collect that at your leisure by going to twit.tv/twill. And that's where we have the archive of the shows. You can find us on iTunes and on YouTube. And we love it if you can join us live or after the fact, however you choose to participate, audio or video. We're just glad that you can come along with us and be part of the show. Between the shows, we're really glad to interact with you too. It's how we get ready for the shows and know what it is that's on your minds and important out there in the world that requires discussion at the intersection of law and technology. So give us a shout on Twitter. I'm at D Howell there. Evan is Internet Cases, or head on over to our Facebook page or Google Plus page. We love to hear from you, however it's convenient for you, including by email. I'm Denise at twit.tv. Evan is Evan at twit.tv. So let us know what's on your minds and keep on keeping on. We're looking forward to seeing you next week on the next episode of This Week in Law. Take care.